I'm Linda Baker, the Learning Director at the Center for Research and Education on Violence Against Women and Children. On behalf of the Learning Network and Knowledge Hub team, I would like to welcome everyone to today's webinar, Legal Advocacy to End Discrimination Against Women with Disabilities. Please think about the traditional lands you are currently situated on and join us in acknowledging and thanking the generations of Indigenous peoples who have cared for these lands and in celebrating the continued strength and spirit of Indigenous peoples. The ongoing work to make the promise of truth and reconciliation real in our communities, and in particular, to bring justice for murdered and missing Indigenous women and girls across the country, should inform our discussions in this webinar and beyond. It is my pleasure to introduce our first speaker, Bonnie Brayton. I have known and worked with Bonnie for many years now, and myself and our team, we can speak without hesitation to say she is an amazing advocate for women with disabilities, women in general, and women with disabilities here in Canada. And I think one of the things to know Bonnie is to know that she doesn't shy away from those really difficult conversations. And she's had a few of those with me, and I'm grateful to her for them. You can read on our website more about her. There's more about her here, but please know, if you don't know Bonnie, that she's the National Executive Director of the Disabled Women's Network, Dawn Canada, and she's been in that role since May 2007. Bonnie, we are delighted to have you with us on this panel, and I'm really pleased to turn it over to you to start us off.
Well, first of all, thank you so much, Linda, and of course to the Learning Center and to your whole team for putting together today's webinar and for the opportunity to be part of this webinar with you and my other colleagues. So there's a content warning, and I'd like to acknowledge that Dawn Canada is working on the unceded territory of the Kanien'kehá:ka territory. Dawn Canada is an intersectional feminist disability organization whose mission for 35 years has been to end the poverty, discrimination, violence, and isolation experienced by women living with disabilities and deaf women through leadership, partnership, and networking. Today, we are honored to be with three of our most valued partners. Working with LEAF, ARCH, and the Learning Center is just one example of how we affect change. We thank all the participants for taking the time to participate in this webinar, but we remind everybody that meaningful change will only come when legal advocacy for gender-based violence is fully engaged in intersectional practice. I'm sharing this slide, and it's part of a submission that I actually made to the Senate Committee on C7, Medical Assistance in Dying, but I share it today because it's very relevant to the larger topic and an important opportunity to highlight something that Justice Beverly McLaughlin wrote in the Judge's Handbook. The Constitution and a variety of statutes enshrine a strong commitment to equality before and under the law, an equal protection and benefit of the law without discrimination. This is not a commitment to identical treatment, but rather to the equal worth and human dignity of all persons, and a desire to rectify and prevent discrimination against particular groups suffering social, political, and legal disadvantage in our society. And again, this is from the Judge's Handbook 2014, and it is Justice McLaughlin quoting from the Eldridge decision. For obvious reasons, and again, you will hear more about the DAI case, that Judge McLaughlin chose this as an example for judges, I believe speaks to the importance of what we're talking about today. Dawn Canada does our work through four pillars, three pillars. That would be a big problem. Research, education, policy, and advocacy. And I was going to say this approach is one that is quite critical to the subject matter today, of course, because it is only through applying our research lens, education, policy reform, and advocacy that we will actually realize the kind of change that we need to see in the justice system for women and girls with disabilities. In fact, one of the things that I thought would be important to remind participants today is that disability is an evolving concept. And this is from the UN Convention on the Rights of People with Disabilities, a document that Canada is signatory to both and to the optional protocol. The implications in terms of how this ties into our conversation today will become more evident as you hear from my other panelists. And when we begin to look at and understand the fact that there were real concerns and continue to be real concerns around the way women with disabilities are identified in the justice system. And I share this slide to remind us of something else that's quite central to our discussion and hopefully to questions today, which is why it's so important for us to come back to this concept of intersectional practice, intersectional law, and where we're going with that. I'm quite sure at this point, many people in our audience are very familiar with intersectionality as a concept. But again, as you can see from this slide, women with disabilities who experience violence as children are also almost 2 times as likely as those who had not experienced physical abuse to be victims in the last 12 months. There's research I know that confirms the overrepresentation of women with disabilities in prisons, again, linked to childhood sexual abuse. And again, this is the criminalization of victims that we see so often in the justice system. One of the things that has really pushed Dawn Canada in this whole area is, I share here an example from the 2017, but invite any participants here to go to the Canadian Human Rights Commission website to see what they will find is that for 10 years, the majority of human rights complaints in this country, again, I'll just say again, the majority of human rights complaints in this country have been disability related. At the federal, provincial, and territorial tribunals, this is the case. So what we have here is evidence of deeply systemic discrimination, and something that, like I said, is not just theoretical, but evidence for a number of bodies, including the human rights tribunals and commissions, and those who work in the area of human rights. Dawn Canada developed an entire initiative, in fact, out of the evidence that comes from the Human Rights Commission, which we call Do the Rights Thing. And Do the Rights Thing is really towards the idea that we have to begin to address disability rights at a systemic level. Evidence shows that discrimination on the basis of disability is a systemic problem. We've understood, I think, in larger conversations, the concept of systemic racism, and systemic ableism is another part of how we go forward in addressing the situation of women and girls with disabilities. Click, okay, there. Dawn Canada also wanted to highlight something that was important in terms of what happened when the Accessible Canada Act was being developed, which is that there was an amendment made by the Senate in response to gender, sexual orientation, and race, referencing the specific marginalizations that create additional barriers for some Canadians with disabilities more than others, and came to be a preamble in the Act that actually focuses on intersectional discrimination. My colleagues from Arch and from LEAF will spend some more time on both of these cases, but I, of course, wanted to cite them as two of the key cases we would like to look at today. The DAI decision from 2012, again, was overseen in terms of the presiding judge at the Supreme Court was, in fact, Judge McLaughlin, and it was with LEAF that we intervened in this case. And again, DAI was related to a woman with an intellectual disability who reported her stepfather sexually assaulted her. She was not believed, and she could not understand an oath or promise to tell the truth, the case was dropped. This was at the provincial level. The appeal went forward with Dawn and Leaf, and a decision was made. That decision and the importance of that decision in terms of where it provides us with both context for the fact that I've learned since then, and Dawn Canada knows that these decisions are applied widely by Crown prosecutors. But I was going to say it's also really important for us to begin to think about it in the context of how we share this information, both with service providers, with policymakers, and of course with women with disabilities themselves. So without further ado, I'd like to just quickly play this video. There's a technical problem, or what's happening? I don't have screen sharing, so it's not me. Don't know what's going on, but we can't see.
Bonnie,
Yes.
it's okay. Can you, oh, maybe Sarah's got it now. Okay.
Yeah.
I didn't like what you did to me.
What you did felt bad.
Any unwanted sexual duty is wrong.
You can't touch me.
Unless I want you to.
The people who understands how we communicate. We don't accept abuse. We can tell. We will tell.
Thank you. How am I doing for time, Linda?
You've used 8 minutes, Bonnie.
Okay, good, thanks. So that video, of course, is available. It's available in French and in English with ASL and LSQ, and is an extremely useful tool, like I said, to a number of audiences. So I encourage people who are familiar with the DAI decision to use this in any context that you feel it would be useful. We, of course, have used it to great extent in terms of I think something Carrie will talk a lot more about in terms of education and developing more educational tools so that people really understand the meaning and purpose of decisions and how they impact victims is something that we think is so important. So
Sorry, Bonnie, sorry
Yes?
to interrupt. We need to switch the spotlight on the interpreters to Rogue, please.
Okay, thanks. Good to go, Rogue? Great, thank you. So this is a quote from the press release when the Slatter decision was taken, which was in November, I think, or December of 2020. And again, a very important decision where both Leaf and Art were involved with Dawn in moving this forward. And a really important decision again regarding what we see happening again through the DAI decision, and something again that, like I said, is well known to this audience, which is the reality that there's a higher rate of gender-based violence against women with disabilities, but the other reality that not many of those cases actually make their way all the way through the system, and certainly not to the Supreme Court to be held up the way these ones have. So they become important tools for you in your work. In the context of the Slatter decision, as I said, it is another decision, I think, that, like I said, begins to create a body of work that shows evidence that it's time for important changes in the courts and in the way that judges, prosecutors, and those who actually support women with disabilities who report a crime are supported. So one of the things I wanted to say, and again, I know I'm getting close to the end of my chance to speak, and I know we'll have chance to speak some more later, was to say that Part of the reason I'm also sharing this information is because it was something that I found out when I was preparing for a conference a couple of years ago in front of the Crown prosecutors in Ontario. And I was delighted to have a chance to speak with the Crown prosecutors to talk about the DAI decision, and in fact learned that many Crown prosecutors have used the DAI decision effectively. This is just for anybody who's interested to look not just at our cases, but for cases in general, that this resource from I think it's pronounced Canley. I don't know how you would say it, but I was going to say it's a resource that's available that will give you examples of how citations have been used. And in this case, you can see that although the Slatter case has only just been decided in November 2020, it's already seen citations as in court. So again, I would say sometimes for all of us, the abstraction of Supreme Court decisions leave us not sure that this work that we're doing is making a difference. But I want to say with great emphasis and with great gratitude to both Leaf and Arch, that these kinds of decisions clearly have great merit in bringing them forward, and that there's more work to do in seeing how they are interpreted, how they are applied, and how these decisions and others going forward will begin to truly give young women and women with disabilities in general the confidence to come forward and make a complaint. As you saw from that video that I shared with all of you, it's really important that young women with disabilities and women with disabilities in general know that if they do come forward, they will be supported, and most important, that they will be believed. This is not something that we can take for granted, as these Supreme Court cases have established. I want to thank Linda and again, Leaf and Arch for the important work that you're doing to provide this kind of information to a wider audience. Thank you. Miigwech.
Thank you, Bonnie, and thank you for setting the stage for our next two presenters and for today's webinar. And again, we'll hear more from Bonnie and you'll have a chance to ask questions later on. I'm really pleased to introduce our next speaker. Roselle Kim is a staff lawyer at the Women's Legal Education and Action Fund, LEAF, who lives and works in Toronto. And I think that many of us may be somewhat familiar with Roselle because of her presence in helping to educate us all in places like the Toronto Star and CBA National and Puritan Magazine, just to name a few. Roselle is a frequent speaker on gender equality issues. She serves on the board of the Korean Legal Clinic, which aims to improve access to justice for Korean Canadians by providing culturally and linguistically appropriate legal services, education, and resources with partner organizations. Roselle, thank you for being here today, and I'm really pleased to ask you to now make our next presentation.
Thank you so much for that generous introduction, Linda, and thank you everybody for joining us today. Good afternoon, everyone. My name is Roselle Kim. As Linda mentioned, I'm a staff lawyer at the Women's Legal Education and Action Fund. Really great to connect with so many advocates today from across the country. Let me just move this slide. So my presentation today is to provide a bit more detail on the cases that Bonnie mentioned in her great presentation. So it's divided into 4 parts. So first, I'll talk a little bit about, so my apologies, I just lost the screen for a bit there. So I'll begin with some introductory remarks to talk about LEAF's work, including its main litigation strategy of intervening before the courts. Then I'm going to talk about the 2 cases that Bonnie had already mentioned, which is the Queen and DAI and the Queen and Slatter, and conclude by offering some thoughts on barriers that complainants labeled with an intellectual disability face in accessing justice. So just to situate myself a little bit, I'm speaking to you from the city now known as Toronto, Takaranto, which is governed by the Dish with One Spoon Covenant, which is a nation-to-nation peace agreement between the Anishinaabe, the Chippewa, and the Haudenosaunee people to protect and take care of the land. In thinking about advocating for women with disabilities, I think it's really important for us to situate ableism as both a distinct source of oppression and as a continuation of racism and colonial violence. So, and to talk about my position a bit further, I identify as a settler and an immigrant and a non-disabled person. So I want to say that I make my remarks to you as someone who's a representative of LEAF, who was involved in these cases, but not someone who has lived experience or expertise in disability rights. And I defer to Bonnie and Carrie to offer those perspectives. So I think that's all I'll say for my introduction, and I'm going to move to the next slide. So just a quick introduction, and as Bonnie mentioned, I will also be talking about sexual assault in my presentation. So please feel free to take care of yourselves in a way that you need during the session. And now I'll briefly talk about LEAF. As I mentioned earlier, LEAF is a national, charitable, and nonprofit organization with a mandate to advance substantive gender equality in Canada through litigation, law reform, and public education. Since being founded in 1985, LEAF has been involved in over 120 cases, many of them before the Supreme Court of Canada. These involve many areas of the law, including sexual assault, pay equity, access to reproductive services, among others. LEAF's role in the courts has been mostly been as an intervener before the courts. So an intervener is someone who's not originally a party to a case or proceeding, but an intervener is given status by the court to participate and provide a helpful perspective to the court, such as a public interest perspective. So LEAF intervenes in court cases to discuss implications of a case from a gender equality perspective that would extend beyond this individual case. So now that I've done that, I'm going to now get into discussing the DAI case. Bonnie has talked about this case already, but I'll provide just a bit more detail. As she mentioned, this case involved a woman named KB, who was labeled with an intellectual disability. And she reported to the teacher that her stepfather played quote unquote games with her that involved him touching her sexually. And she gave a videotape statement to the police. She also gave evidence at the preliminary inquiry before the trial via her video statement. And she was cross-examined as well on the videotaped statement. And at trial, DAI challenged the complainant's competence to testify. So I want to just step back and talk a bit about the terminology that I'm using here. And I think that we will have a discussion about the importance of language in advocating for disability rights. So I'm going to use the terms complainant here because we are talking about these cases in a legal context. And I'm also going to talk about the complainants being labeled with an intellectual disability. And I'll talk a bit more about why I'm using that term when I talk about the Slatter case. But I also wanted to say that when we made submissions on DAI, we used the terminology of people with mental disabilities at the time. So I do want to note that the terminology, and I hope that we can have a more in-depth discussion about the role of language. So you may know that witnesses who testify before the courts are usually asked to swear an oath or declare that they will tell the truth. The Canada Evidence Act, which governs evidence including witness testimony, has set up specific rules about competence for witnesses who are 14 years or older, or witnesses whose mental capacity is challenged, and that's the wording in the Act. And if there is a doubt that the witness does not understand what an oath or declaration is, the Act states that a trial judge has to determine two things. One is that the witness is able to communicate the evidence, and two, that they make a promise to tell the truth. And if the trial judge decides that these two requirements are met, then the witness can testify. DAI argued that these two requirements were not enough, that the complainant had to understand, the consequences of not telling the truth, and that she understand the nature of the promise, for example. And you might read this and think that this seems reasonable, but if you think about the implications of this as a whole, the impact is that it's only adults labeled with intellectual disabilities that have this extra burden of demonstrating that they understand this concept of a promise, whereas non-disabled witnesses don't have this burden because they benefit from the assumption that they understand already. And if you look at why these extra steps are being imposed on adults labeled with an intellectual disability, there is the assumption that witnesses labeled with an intellectual disability are lying, or that they're simply not able to tell the truth about what happened to them. So the trial judge concluded that the complainant did not show an understanding of her duty. And if you sort of look at what happened at the trial, there is a difference between the prosecutor who questioned the complainant much more, and that process was much more based on factual things like the color of the wall, whereas when the trial judge is questioning her about things, the line of questioning is much more abstract about the duty, consequences of what happens when you lie, etc. So as a result of this, the trial judge excludes the complainant's out-of-court statements, that includes this videotape statement to the police, and finds them to be unreliable. And then DAI was acquitted, and the Court of Appeal of Ontario affirms the acquittal, and then this case goes up to the Supreme Court. So now, just move this slide. So Leaf and Dawn intervened before the Supreme Court to argue that if the trial judge's holding is upheld, or if the lower court's holdings are upheld, this would prevent complainants with what we called at the time mental disabilities from accessing justice, despite the pervasiveness of sexual violence against women with disabilities. And this would worsen their victimization, devalue them as human beings, and allow their abusers to continue the abuse. And yes, and as was mentioned before, the majority of the Supreme Court of Canada held that complainants with disabilities who could communicate their evidence then only needed to promise to tell the truth to be able to testify, and not demonstrate an understanding of the duty to tell the truth. And the majority, I just included a paragraph here where the majority says, to set the bar too high for the testimonial competence of adults with mental disabilities is to permit violators to sexually abuse them with near impunity. So that was DAI. And now we are going to jump about 8 years to a case called the Queen and Slatter. And we have sadly here another case of a sexual assault against a woman labeled with an intellectual disability. So here, the complainant's name is JM. She disclosed sexual assault, and at trial, the defense counsel argued that JM's evidence was unreliable because her disability made her suggestible. And by this, they meant that people could suggest things to her and that she was more easily influenced by people's suggestions. The trial judge didn't accept these submissions and convicted the accused of sexually assaulting the complainant. So that the accused appealed to the Court of Appeal for Ontario and argued that the trial judge failed to sufficiently explain why the trial judge found the complainant reliable. So then the majority of the Court of Appeal for Ontario overturns the conviction and orders a new trial and finds that the trial judge's reasons were not sufficient. And this time again, the complainant's reliability becomes an issue. So let me just move the slide. So a coalition of Leaf, Dawn, and Arch intervened in this case to provide an intersectional perspective to the court. And here the coalition argued that a substantive equality analysis requires the court to make assessments based on the actual abilities of the individual circumstances of women with disabilities, such as their ability to describe what happened, as opposed to generalizations about disabilities. And we put forward this argument to draw attention to the fact that here the court sort of weighed the expert report that discussed the complainant's abilities rather than paying attention to what the complainant said on the stand and her conduct. And that record suggests that she actually was able to, stand up to the defense's line of questioning. And instead of being suggestible, she's able to, repeat her story and answer the challenges that are put to her. So I think that I'm almost out of time, but I'll just say that this case goes up to the Supreme Court. It's heard in November. And then the Supreme Court issued a pretty short ruling from the bench, which means that they released the decision on the same day that the case was heard, which is kind of rare, and allowed the appeal and ordered a new trial. The court adopted a lot of the coalition's arguments and highlighted that when assessing the credibility and reliability of the testimony given by an individual who has an intellectual or developmental disability, courts should be wary of preferring expert evidence that attributes general characteristics to that individual rather than focusing on the individual ability. So that's the case of Slatter, and that's the case where I was fortunate to work with both Bonnie and Carrie. And I'll just conclude by discussing a couple of points for consideration. Oh, I'm also just seeing that I think my online clicker is having trouble connecting. Let me just try again. Oh, here we go. So I just wanted to quickly talk about sort of 3 points, which I hope that we can discuss later in our moderated discussion. So the first point that arises from these cases is sort of the persistent institutional ableism. And I say institutional ableism here, where to talk about how the justice system sort of perpetuated some of the ableism that we see. And one way we see this, see how institutional ableism manifests is that reliability becomes a very live issue in both cases, where the complainants are scrutinized on their ability and questioned on their ability to tell the truth, and how the court pays more attention to the experts than the complainant's own words, for example. And this assumption that a person with disability is often lying, simply unable to tell the truth, these kinds of and how these assumptions play out at the institutional level. And the second point I want to make is how this institutional ableism then marginalizes women with disabilities and makes them more vulnerable to abuse and violence. And we listed some of statistics from Statistics Canada in our submissions in Slatter, where StatCan found that women with disabilities were more likely to experience physical or sexual assault by an intimate partner, and more than half of women with disabilities have been physically or sexually assaulted in their lifetime. And lastly, I just wanted to touch upon the terminology. So everything that LEAF works on what we call a committee model, which means that every issue or case intervention we work on, we assemble a group of committee members with expertise in the particular area. So the Slatter case committee had legal academics and community advocates that helped us guide our arguments. And one of the case committee members for Slatter was Shelley Fletcher, who's the executive director of People First of Canada. And she discussed the importance of this term, where intellectual disability is not an inherent condition, but sometimes you just become a part of the system that labels you as this, and regardless of your ability, and it's really the institution that determines your ability, and it's not something that's inherent. And I think that was an important point, and I hope that we can discuss the importance of terminology a bit more. And I think I'll end there. So thank you so much, and I'll just move on to the next slide with my contact information if anyone has any questions.
Thank you so much, Roselle Kim. You took a really complex cases and very succinctly helped us understand and get a sense for this important work and the significance of it. So we really appreciate that and look forward to the questions and further discussion on some of the issues that you raised. I'm now going to introduce Carrie Joffe. Carrie is a human rights lawyer at Arch Disability Law Center. She's been involved in disability rights litigation at various tribunals and courts, including the Supreme Court of Canada. Carrie has presented law reform and policy submissions about disability law issues to legislative committees, governments, administrative bodies, and the United Nations Committee on the Rights of Persons with Disabilities. I think that one of the things, and you can read more, but I know we want to read about her at our leisure, but hear from her now, is that Carrie not only holds a law degree, but is a social worker and has studied social work. And I don't know, something tells me maybe all of these things come together in such an important way in her work. Carrie, thank you for being with us, and I'm delighted to turn it over to you now.
Thank you very much, Linda, and thank you to everybody at the Learning Center for inviting me to join today's webinar. I want to acknowledge, sorry, I'm just going to, there we go, the slides are working well now. Okay, I would like to acknowledge my place in creation and also note that Arch acknowledges that since time immemorial, the land on which we work has been home to Indigenous peoples, including the Mississaugas of the Credit, the Haudenosaunee, the Huron-Wendat, Inuit, and Métis relatives. We are here as guests, and we are grateful to our hosts today and every day. So I will start my presentation by just talking a little bit about Arch Disability Law Center, which is the place where I work. For those of you who are not familiar with Arch's services. And then I'll talk a little bit more about the Slatter case that Bonnie and Roselle both dealt with in their presentations. And I'll also try to give you some other examples of work that we've done to advocate to end discrimination against women with disabilities outside of the court. So in Parliament and in law reform and at the United Nations. So Arch Disability Law Center, or Arch as we call it for short, is a specialty legal aid clinic. And we have a mandate to advance and defend the equality rights and human rights of people with disabilities in Ontario. We do that in a number of different ways. We offer a variety of legal services to people with disabilities living in Ontario, including summary legal advice. So people with disabilities can call and get a free confidential half-an-hour appointment with one of our lawyers for legal advice about various areas of law in which we work. We also represent people with disabilities and disability organizations in test case litigation. Slatter is one of those test cases that we worked on, which Roselle and Bonnie mentioned, and I'll add a little bit about my perspective on that case. Public legal education is a very, very important part of the work that we do. We frequently go out into the community and talk to people with disabilities and communities of people with disabilities about their legal rights and about how to advocate and defend their legal rights. We also do quite a lot of law reform work, which is where we speak to governments and policymakers to help them understand how they can improve laws and policies that affect people with disabilities. And we also do community development where we try to contribute to build community capacity to advocate for better implementation of the rights of persons with disabilities. Part of our work also includes national and international disability rights work. Although our primary focus is Ontario, many of the federal laws and policies affect people with disabilities in Ontario and throughout the country. And so we think it's really important to make sure that we also advance the rights of people with disabilities at the federal level. And of course, at the international level, within the United Nations system and in other international legal forums, there are also opportunities to raise awareness about the rights of people with disabilities and put pressure on the governments of Canada and our provincial and territorial governments to better promote and respect the rights of people with disabilities. And so we try to take those opportunities to do that as much as we can. Arch is governed by a volunteer board of directors, and the majority of our directors are persons with disabilities. That's really important to us to be accountable to the community and communities of people with disabilities and the work that we do. And the primary funding for our clinic is received from Legal Aid Ontario. So I just wanted to highlight 3 elements of our work that I think are really relevant and important for the discussion that we're having today. First, Arch takes an intersectional approach. So this is actually part of our mission statement at Arch, to address the heightened disadvantage and discrimination experienced by persons with disabilities as a result of discrimination based on gender, sex, race, age, language, place of origin, economic status, sexual orientation, and other intersecting forms of discrimination. We also take a systemic approach to our work. Like Dawn and like Leaf, we are a relatively small group of very dedicated but staff at our office. So we really need to focus our efforts on ensuring that the impact that we have will affect as many people with disabilities throughout Ontario and Canada as possible. And so we try to do that by making sure that the law reform and the litigation that we do focuses on removing and preventing systemic barriers and systemic and institutional discrimination that affects people with disabilities. And finally, we also take a cross-disability approach. And that means a number of things, including that we respect the diversity that's inherent within disability communities, And we recognize that while all disability communities are striving for full inclusion and equality, different communities have different priority issues that they are advocating for. So as much as possible, we try to work with coalitions of disability communities to address human rights issues that impact people across disability identities. Okay, so getting to the fun stuff. I wanted to give you some examples from litigation work that we've done to address discrimination against women with disabilities. Bonnie and Roselle both talked about the Slatter case, and that's the first bullet point on my slide. Arch was one of the interveners in coalition with Leaf and Dawn that participated in this case at the Supreme Court. And I certainly agree with all of the points that Bonnie and Roselle have made about the importance of this case. I wanted to also highlight that while the case focused on barriers and stereotypes faced by women labeled with intellectual disabilities, the lessons learned, I think, must also be understood as being broadly applicable to all cases involving women with all different kinds of disabilities. And I think the Supreme Court recognized that as well. The Supreme Court used broader language in its decision in Slatter and didn't limit the outcome of the case or the important legal principles in the case just to cases involving women with intellectual disabilities. It used broader language indicating that the reasoning in the case is more broadly applicable. And that broader language is evident in a quote from the Supreme Court's decision, where the court said, "Over-reliance on generalities can perpetuate harmful myths and stereotypes about individuals with disabilities, which is inimical to the truth-seeking process and creates additional barriers for those seeking access to justice." And so I think it's important for all of us to remember, that's the legal principle that we can use and we can apply to women with disabilities in all kinds of situations in the justice system. I think the case also highlights another barrier that we at Arch see regularly in the kinds of cases and legal issues that people with disabilities bring to us. And that is the over-reliance by courts and tribunals on medical evidence and medical opinions about disability. And I think we see this play out in the criminal justice system, for example, in cases like Slatter, but I think it also plays out in many other legal contexts. One that comes to mind quite readily is divorce and custody cases where women with disabilities may have their mental capacity questioned on the basis of a medical opinion that the woman's disability prevents her from making decisions about her own case or from directing her own case. And that can lead to all kinds of ways that the rights of women with disabilities are undermined in those kinds of cases. In some cases, we've seen a court will appoint a litigation guardian, which is somebody who will make decisions for the woman about how her case will proceed. And that really results in the woman losing control of her case. And so those are the kinds of situations where we see disability being used as a proxy for or a reason to challenge a woman's legal capacity, even though she may very well have the ability and the wherewithal to direct the course of her own case. I also just want to say that although Slatter, the outcome in Slatter was a win, and we definitely celebrated that win at Arch, and we celebrated with Leaf and Dawn. I think it's also important to comment on some of the limitations of the decision. As Roselle mentioned, the submissions that we made to the Supreme Court highlighted that women with disabilities are overrepresented among sexual assault survivors, and that they experience multiple and intersecting barriers in reporting sexual assault. And the case has been criticized where for the fact that the Supreme Court didn't really engage with that element of the case, that sort of gendered element of sexual assault. And critics have pointed out that a more explicit recognition by the Supreme Court would have recognized systemic intersectional discrimination as an important contextual factor in their reasoning, and really given some guidance to courts in the future about how that intersectional discrimination should be taken into account in judicial reasoning. So I think that perhaps was a missed opportunity by the court. I wanted to talk very, very quickly about another case. This is an older case. It's from 2009, but I think it helps us to understand some of the barriers that women still experience in the justice system today. So this is a case called Child and Family Services of York Region versus HC. It's an Ontario case, and it was a child protection case where both parents were deaf and communicated using American Sign Language. In this case, the Children's Aid Society had argued that there had been some neglect on the part of the parents of the child, and that they were asking the court to make the child a Crown ward. Both the parents objected, and the lower court ordered the child to be returned to the custody of the mother with supervision by the Children's Aid Society. And the court also ordered that the Children's Aid Society provide the mother with a worker who was familiar with American Sign Language. So that was significant because that was the mother's primary means of communication with the Children's Aid Society. And the Children's Aid Society appealed that lower court order and argued that the court should not have ordered them to provide a worker familiar with American Sign Language. So in that case, Arch represented an intervener, the Canadian Hearing Society, in the appeal. And we argued that the court's order for the Children's Aid Society to provide a worker familiar with sign language was consistent with an equality analysis, and also consistent with the Children's Aid Society's legal obligations under the Human Rights Code in Ontario to accommodate the mother's disability. Ultimately, the divisional court, that was the court that heard the appeal, affirmed that the child should be returned to the mother's custody with supervision by the Children's Aid Society, but the court did not require the society to provide a worker familiar with American Sign Language. And again, I said this is an older case, but I think it's an example of the kinds of barriers that women with disabilities often experience, and that make critical support services inaccessible to them. In this case, the mother had not received the full extent of the Children's Aid Society's supports and services because she was not able to properly communicate with the Children's Aid Society worker without the presence of American Sign Language interpretation or a worker familiar with American Sign Language on a regular basis. And so I think, the case also illustrates, I think, some of the resistance that we often encounter by service providers and employers to making their services or employment fully accessible to people with disabilities and women with disabilities. And perhaps also some barriers in judicial reasoning and understanding of the critical role that disability accommodations play.
It's your 5-minute cue.
Thank you. Okay, so turning to an example from law reform, Bonnie talked a little bit about this in her presentation. The Accessible Canada Act is a federal accessibility legislation that was passed in 2019. And it has the goal to make the federal government, federal businesses, and federal organizations fully accessible by the year 2040. And so it requires those federal government and businesses and organizations to develop accessibility plans and to develop ways to remove barriers in employment, in federal programs and services, and communication and other areas. When this legislation was being developed in Parliament, Arch, in coalition with Dawn and many other disability groups from across the country, conducted extensive advocacy to try to strengthen the legislation. And one of the key points that we advocated for was that the Act needed to recognize intersectional discrimination as a barrier. I'd like to think we were very successful in that advocacy, along with Dawn and the other groups that we joined with. And the Act, as Bonnie mentioned, now includes a specific section, Section 6, which I put on the slide for you there, which says that it must be carried out in accordance with the principle that laws, policies, programs, services, and structures must take into account the disabilities of persons, the different ways that persons interact with their environments, and the multiple and intersecting forms of marginalization and discrimination faced by persons. And so as a result of this provision in the Accessible Canada Act, the federal government, businesses, and organizations must consider and operationalize this principle around intersectional discrimination when they develop their accessibility plans. So the first accessibility plans will be developed by summer 2022. And there's much work still to be done to really implement this principle and figure out how it's going to translate into real world application. But I think the explicit requirement in the law for organizations to identify and remove barriers related to intersectional discrimination is really significant. And it has real potential to lead to much greater awareness and action to remove barriers experienced by women with disabilities in federal employment programs and federal courts and tribunals as well. I had wanted to talk a little bit about some of the work that we do with Dawn and with a number of disability groups across the country at the United Nations. But I think I'm probably out of time. So perhaps that is something that if people are interested in, we can get to in the Q&A portion of today's webinar. So thank you very much, everybody. And I look forward to our discussion, our moderated discussion and question and answers.
Thank you, Carrie, for bringing us home. And I appreciate, I'm sorry we had to miss out on that, but hopefully you will have a chance to bring some of that into the discussion that we're now going to have with all of the panelists. And I think that they're going to join us on screen very shortly. So that's wonderful. We have a few questions that we want to present and give all of you a chance to respond to. One of the things that really stood out to me as you were presenting was the importance of language. And you were providing context at times. And of course, you're working in a legal context, but you're also working in an advocacy context, of course, educational context. And we wondered if we could pose to you to reflect on what language is most constructive and empowering to women with disabilities. And I would like to, and you can take that where you want in terms of each of your own specialties and experience, but I wonder if we could ask you, Bonnie, to start us off with that.
Gosh, I wish I had a chance to look at the questions before, so I would have had a really sharp answer for right off the hopper. There's a lot to that question and a lot to the whole area of language. So I'm glad that we're talking about it. It's certainly something that we talked about ahead of the panel and that I wrote down. And like you said, different references were made to that. There's so many different ways that the language thing comes up. I think I want to talk about it first in the context of some of what we talked about in the decision and in the justice criminal in the courts, which is, of course, the mental disability one is one that I think is an important one to draw attention to. And a complicated one because that's the term that's used. And as we heard from Roselle, there's a way to use it to advantage when you don't want to do the labeling. But at the same time, mental disability is a very antiquated way of referencing anything in the context of language for people with disabilities, because we don't talk that way and we don't think of ourselves that way. And that whole siloed approach, and even the fact that I think was another really important point my colleagues on the panel brought up, is the idea that we're going to limit ourselves to this intellectual disability idea, and that it's one that also gets perpetuated a lot by the way decisions are sometimes named. So I appreciated the other point that Carrie raised around the fact that there was a distinctive difference between the first and second decision around the intellectual disability piece being left out, but that there were weaknesses, for example, in the decision at Slatter in terms of not recognizing gender-based violence or intersectional discrimination in the way that we would have hoped. So I think one of the other things around language, Linda, and again, I'm not really answering the question directly, but touching on the language piece, right? Because I saw questions in the chat box too, is again, the question of deaf, capital D deaf, and why do we say capital D deaf, and what does that mean? And the concept, and like I said, I saw it raised in either the chat box or the Q&A of deaf culture. And even a question was, I think, sent to Carrie during her presentation about this idea. And so it is for people to understand too, that this idea of labeling in general is something that presents a problem, because people from the deaf community do not consider themselves to be people with disabilities, but in fact, deafness is a culture and a language. So there's so much more to this discussion. I can't do it justice. I really think it's important to hear from Carrie and Roselle about this in terms of the context of language in the courts, and appreciate also one of the other points they made, which of course is women being labeled with an intellectual disability. And of course, something that I know Shelley had shared, and that I'm not surprised Shelley shared, because it's such an important point to make as well, because these labels and this whole notion of separating women with disabilities in the court system is really the core issue we're talking about. So I'll leave it there, and look forward to hearing from Kim and Roselle and Carrie. Thanks.
Okay, Roselle, do you want to pick it up from there?
Yeah, and it's a great question, but also a complicated question, as Bonnie already alluded to. Yeah, I'm not sure if I have an exact answer, but I think 2 points I'll make is that I think that language is evolving and it's imperfect, or it cannot, possibly capture all the complex, our complex realities that we live in. So just understanding that, and being ready to to evolve the terminology. And I think that evolution has to be guided and led by people who are most impacted by that language. And I think as long as we sort of keep those principles, and I'm hoping that we can then we can have language that gets close to the lived realities of everyone.
Just before Carrie answers too, Linda, to build off what Roselle just said also, is to remind the participants that we shared that in the UN CRPD, in fact, disability is named as an evolving concept. And that one of the things that we're up against here in this larger conversation is the very siloed approach that's been taken to human rights, and the very fact that our court systems have not really caught up with where we are in terms of, as a society, in terms of the way we live. And the tension around the idea that we still have this very siloed approach to the way we report on human rights, and the way that decisions seem to be rendered based on a label here and a label there. Thanks.
That just sounds like the perfect segue to you, Carrie.
Well, I certainly want to echo what Roselle and Bonnie, their comments. I think, from a disability rights perspective, language is so critically important. Language has historically been one of the tools that have really marginalized and excluded people with disabilities from all aspects of life. So I think it is really, really critical to take our cue on language from communities of people with disabilities. Some disability communities prefer people first language. For example, the comments Roselle made about that we heard from Shelley at People First of Canada, who prefers to use the term person labeled with an intellectual or developmental disability. really signaling that, people are people first, not the label or the identifier that's been placed on them. And I think the labeled with also really speaks to the social model of disability, which is that it is social structures, including the medical profession, and the way that society is set up, that produces the experience of disability or barriers that prevent people from really participating in life, rather than the fact of having a disability or not. To the contrary, I think, there are also lots of communities, people with disabilities that prefer disability first language. And again, signaling that the importance of disability as an element of their identity. And there are also many communities, people with disabilities, who have reclaimed formerly derogatory or discriminatory words. Some we hear about the women with, historically women have, I think, been labeled as mad or crazy in a lot of contexts, but that term mad has been reclaimed by some communities to refer to referring to themselves as mad people, or the study of the oppression perpetuated by the mental health system as mad studies. And so, again, very complicated question, but I think just to maybe sum it up in one word, like what language is most appropriate, I think it's really important for us to defer to the particular person or community that you're working with in terms of what they prefer. And, when we're doing our work in courts, that piece around language is so critical, like as a piece of judicial education. It's always something that we try to include in our legal arguments. And I know Leif and Dawn also pay very close attention to that as well.
Okay, thank you so much. And you've given us lots to think about. And I realize, as Bonnie started off, this could be a week-long discussion. So, but I want to get to some other questions and have time for some from the audience as well. So one of the things that also shone through in all of your presentations was the importance of an intersectional understanding and approach. And when we think of ableism and autism intersect with further forms of oppression like racism, cisnormativity, colonialism, how can we promote dialogue across communities and institutions to combat all forms of oppression? Not losing any, but combating all, and getting the strength that comes from that working together. And I'm just wondering if we could go back to you, Bonnie, to start us off in terms of thinking about that question. And again, I know it's a big one.
It's a big one, but it's probably the most important one in terms of actually making a change, Linda. And it's the hardest conversation to have, because each one of those issues individually, racism, sexism, heteronormative, all of them are forms of discrimination that have caused great harm to individuals. And, as Carrie pointed out, people have different ways of identifying themselves and which part of that person they feel is being discriminated against can change based on the situation and so many different things. And so the consequence of that is you simply cannot stay in the silo and have meaningful change happen. We've seen that because we have all of these great treaties and all of this good intention. But the reality is Dawn Canada just finished 35 years in service and things haven't changed. We didn't have a year of celebration, we had a year of reflection. And we're about to launch a 10-year vision for change, because that's what has to happen. Canada has adopted the National Action Plan, and that's a 10-year runway for us. And it gives me hope, because it's deep systemic change that we're talking about. So it's not a question of how, it's a question of when only, in terms of how we're going to affect change, because until we see ourselves for the collective strength we have as rights holders together, that we will actually affect change, because otherwise they do exactly what they do all the time, which is set us up, compete against each other, and it becomes, You know, the oppression Olympics is one of our favorite expressions in the work, because that's what starts to happen. And it's not because anyone is more important than the other. They are all significant, and they all interplay in terms of how somebody does or doesn't have a good experience. You know, intersectionality isn't always negative. And that's another thing that's a really important part of this conversation going forward. It's the beauty of intersectionality that we need to celebrate, and the strength of it that we need to focus on, not the complexity, because that's for sure something we could focus on, but that's a cop-out. It's a cop-out, and we can't allow that. You know, we will see the change because the facts are there. You know, Dawn Canada finally has resources for research, and we are banging the table with that research now, right? Statistics Canada's got good research. The kind of things that we have now in terms of both qualitative and quantitative, I mean, 24% of women in Canada live with a disability, damn it. 24% of women, 1/4 of all women. I mean, push the button and watch me go, Linda. So yeah, you were good to get me started, but I was going to say, I don't want to go on without hearing from Roselle and Carrie about this, because it is really the central point to exactly why we're trying to do this webinar, and what we're trying to do here is to affect change, and we won't affect it without moving into intersectional practice in policy, in legislation, in services, and the way we work together with respect for each area. Thanks.
Thank you, Bonnie. And I'm just going to go right over to you this time, Carrie, to pick it up and add to the conversation.
Sure, just a couple of quick points to add to what Bonnie said. I mean, I completely agree that, you know, we have to seek out and really create projects and work that allows us to collaborate and get out of our silos. And I think the Slatter case, you know, was a great example where we were able to partner with Dawn and with Leaf and really develop an intersectional feminist approach that we presented to the court. I think that's critical, again, in advancing the law and doing judicial education around, you know, how courts and decision makers should really be understanding the discrimination that's in front of them, not just from the perspective of, you know, one identity factor or one characteristic, but really the person as a whole, and how the various elements of their life sort of coalesce to form that particular marginalization or discrimination that they experience. I also just want to highlight, going back to the Accessible Canada Act, you know, the fact that we have that provision in the law that recognizes intersectional discrimination and actually requires federal government businesses and organizations to create accessibility plans. So the first thing they have to do in creating their plan is actually identify what are the intersectional barriers that are at play within their organization or their particular services, and then figure out a way to address those barriers. So I think that gives us tons of opportunity, again, to do some education and awareness raising about how intersectionality plays out, how it creates particular barriers, and to come up with some great creative solutions for addressing those barriers. And we have to work together to do that.
Thank you. Roselle, what would you like to add?
I don't know if there's much to add after all that's been said. I think just to echo what Bonnie and Carrie have said, I think, you know, showing up and providing support, I think these are all the first steps to creating dialogue. And I think you have to create the relationships, you know, together in order to do this work well. And I just want to say that it was through the Dawn conference, I believe it was early, I actually can't remember, but it was at the Dawn conference that I met Carrie. And and through that conference that I suggested Carrie to leave as one of the council. And just, I think that, so then it's really important to, you know, try to make connections so that you're accountable, that the communities that you're accountable to are reflective of the diversity of the identities that live in this world.
You know, Roselle, I just want to, we've been doing Zoom for so long, but it just speaks to that importance of the opportunity that Dawn is so great at creating and others for networking, for the opportunity to actually connect with people. And again, it just strikes me as so many things. When you drill right down, it comes back to relationship. It comes back to really building those relationships with people that are doing different kinds of work, similar kinds of work, but in different spaces, and really coming together. So I, again, appreciate all of those comments. Just before we go to some of our participant questions, and I think there's been an active chat and lots of questions coming in, so we may have to think of another way or a part two to get to some of all of those questions. But I just don't want you to go into that portion without commenting on so often what we hear from people. And I know you're reaching some folks that maybe don't have an opportunity to hear the three of you and the work that's being done in this area. And one of the questions is, for listeners who want to be allies, who want to be better and stronger allies to women with disabilities, what do you suggest they can concretely do after this webinar? I'm going to switch it up this time, if that's okay. And I'm going to start with you, Carrie.
Sure, a couple of quick thoughts. I can't remember whether it was Roselle or Bonnie, but one of you talked about representation. And I think that's, critical. And so I think one thing that we can all do is really create space for women with disabilities and the organizations that represent them in the spaces that we occupy. So are you going to a meeting with a federal or provincial policymaker or lawmaker? Are you do you have some connections where you're doing advocacy? Like those, I think those are wonderful opportunities to make sure that we include the voices of women with disabilities and provide opportunities for them to represent themselves in those spaces. And I think another piece that's really critical is if you're a service provider or an employer, make sure that the services and the employment that you're offering is fully accessible from the outset to women with disabilities and to people with disabilities in general. I know this is an ongoing project for ARCH. We're constantly identifying new barriers and trying to remove them in the services that we provide and make sure our services are as accessible as they can possibly be. We have some resources on our website if people are interested in with tips and things like that about making services accessible, which I'm happy to provide if people are interested in that. So those are two ideas that come to mind.
Okay, and we will follow up with you for those tips and help drive people to your website and otherwise get there. Roselle.
Yeah, I think I agree with what Carrie said. I think just echoing what I said earlier, just sort of trying to understand, who is doing the work, who are the community advocates and also, people doing this work, and finding them, showing up to events, or they're, following their calls for support. I think those are all good starting points. And also, if you're invited somewhere, just doing a check of who's missing, whose perspectives are not here, and how can I ensure that, how can I support getting those perspectives in the room?
Thank you, Roselle. Bonnie, bring us home on this, and then we'll go to the questions from the participants.
Yeah, thanks. And I'm going to push back on the notion of allies, not because I don't understand the use of the term, but because 1 quarter of women in Canada live with a disability. We're not talking about allies. talking about your sister, your mother, your cousin, your coworker, your neighbor. We're talking about the people all around you. That's who we're talking about. So it's again not to be overly focused on identifying somebody that has a disability, but just understanding that we're everywhere. That's the most important point I want to make, is we're everywhere. After that, I think really, what both Roselle and Carrie were saying, to be more direct about it, it's like, look inside your organization and who is working on your team, who is working on your board, who are your members, and start to address it. It's not rocket science, and I don't want to be sarcastic here, but it really isn't. It really just becomes about being intentional. And it isn't, like I said, about allies. It's about being intentional about changing the culture in your organization to make sure that not just women with disabilities, people of color, Black people, Indigenous people, LGBT folks are part of your team. Because if not, you're missing out on who we are. And I'm not really sure what you'd be doing in this webinar. If you don't think those things are important, you probably wouldn't be showing up here. So I know you hear me. So, it's changed the culture where you are, and that takes time. It is not about finding a bunch of groups of women with disabilities out there, because I'll give you a reality check, they aren't out there. And I don't mean to sound harsh, but seriously, it's like wherever you are in your community, start looking for ways to support the leadership of women with disabilities in any way you can, because you've done it for other women. And we're not any different. We're just part of the other women that you haven't been paying attention to. I'm really grateful for the fact that we've finally seen movement around systemic racism, and that Indigenous and Black women are finally finding space, and that we are finally also creating space for trans women. But inside every one of those communities, the rates of disability are above 30%. Right? The missing and murdered women inquiry. Okay, more than half, I guarantee you, I could promise you this based on anything, including my baby's heads. More than half of the women from the missing and murdered women's inquiry were women with disabilities that did not come up in the inquiry, and that's no joke. These are the kind of things we have to look at in terms of what we aren't doing. So, yeah, everybody pull up your bootstraps. That's what I say. Thank you.
And we count on you to keep us on track here, Bonnie. At this time, I'm going to call on my colleague, Diane Lalonde, a research associate at the center and with the Learning Network team. And she's going to present our esteemed panelists with questions from the audience.
Great, thank you, Linda, and thank you everyone for that rich discussion. The chat and Q&A box, we're definitely buzzing with folks excited to learn from you, and also expressing their thanks and just loving your passion. I'm excited to share some of the questions that came in. I'll start with the first one. It says, institutional ableism is permeated by significant and inaccurate stereotypes regarding women with disabilities. These stereotypes are used to justify this institutional ableism and treatment of women with disabilities in all aspects of life. While R.V. Slater addressed this, what other ways can we use the legal system to challenge and correct these stereotypes? I don't know if you're waving a bug away or raising your hand, Carrie.
There's a fly in the room that I'm in. Sorry, everybody. I mean, maybe I'll take this opportunity to just talk very, very quickly about some of the work that we're doing with disability communities, including Dawn at the United Nations, because I think that's a really important, critical international space where we need to raise, all of these issues about institutional ableism, discrimination, and the intersectional barriers facing people with disabilities and women with disabilities in Canada. So part of that work involves engaging with the United Nations Committee on the Rights of Persons with Disabilities, which is a committee at the UN that reviews how well Canada is respecting the rights in the Convention on the Rights of Persons with Disabilities. That convention is an international law that's Canada ratified in 2010, and it requires Canada to implement all of the rights and freedoms in it. And those rights and freedoms are specifically articulated in the context of disability. So if you haven't yet read the convention, I encourage everybody to go and take a look at it. And so part of the work that this UN committee does is it asks Canada a series of questions about what it's doing to promote and protect human rights for people with disabilities. And NGOs and civil society have an opportunity to engage in that process as well, and to sort of give the UN committee our take on, how well Canada is doing, because as you can imagine, the government of Canada and the provinces and territories like to put a very positive spin on Canada's record on human rights for people with disabilities. And of course, there are some positive things to say, but there's a long way to go, as we've discussed today. So I think that's work that we're doing with disability groups across the country, is to sort of pull together, work together with all of these different communities and try to pull together some feedback for the UN committee, to really try to make sure that at that international level, there's a good understanding about what some of the key priority issues are that the government still needs to address in terms of advancing human rights for people with disabilities, and very much from an intersectional perspective as well.
Wonderful, thank you. Roselle, I see you nodding your head. Do you have something to add as well?
I don't know if I have concrete things to add. I guess I'll just say that the legal system is a big gatekeeper, and it is also a colonial legal system. So I want to acknowledge that, I work at an organization that uses the law as a tool for equality, but we also have to acknowledge that it is also a tool for violence and harm. And I think that we need to acknowledge both these things in order to understand how we can use it. And I think that at a more basic level, there is, and people have been saying this in the chat, that there are issues to accessing a lot of benefits, and just, the legal system is difficult to understand or access, and some of it is by design. So I think for those of us in the profession, the role that we can play is to make sort of the demystify the rules and the law. So there's that service provider aspect, and there's also the aspect of needing to challenge the system itself so that it becomes more inclusive. I don't know if that's helpful.
I see comments saying it was very helpful, so thank you for that. Bonnie, you have anything to add on the question about other ways to use the legal system?
I think I was really happy with what both Carrie and Roselle said. So if there's another question, we can take another question. Thanks.
That's good. Okay, we are a bit tight on time, but I'm going to sneak in one more question if that's okay. So there's a couple of questions wondering about how do you get involved with your efforts? And one in particular said, how can young legal professionals, specifically paralegals, become involved with Dawn, LEAF, and ARC? And maybe Bonnie, we could start with you then.
Thanks, and thank you for the question. I really appreciate the interest. It's a little trickier to say how you could get involved directly with Dawn as a paralegal, but because both Arch and LEAF are partners of ours, and I'm guessing in both cases there are probably opportunities to get us, I don't know what you call it in English, a stage, a training opportunity, with one of their organizations. I think that's a better opportunity for a paralegal. Thank you, Valerie. It's an internship. Yes, thank you. But I was going to say, in terms of, like I said, from the Dawn perspective, it's important to understand because we don't do direct service and we're a network working at the federal level. It's trickier to figure out what to do when people want to come forward and volunteer, but not because we're not interested. So I was going to say there's lots of different ways that you can make a difference as a paralegal. I don't think it's directly through Dawn Canada, but I was going to say anytime you support Dawn Canada and our work, you're supporting us. So like I said, just by sharing the information, talking about it, and starting to make the kind of changes we've all been talking about today are the kind of things that I think would be great. And as Lynn Gell points out, a research chair. Why not, Lynn?
That's great. Thank you. Maybe Carrie, I'll go to you next.
I'll just say quickly that ARCH coordinates a group called the Association for Human Rights Lawyers in Ontario. It's called lawyers, but it's really not only for lawyers, it's for lawyers, paralegals, and community legal workers who practice in the area of human rights and primarily, represent people with disabilities and anybody really making a complaint about discrimination in the Ontario justice system. So if you're interested in becoming a member of that association, feel free to reach out to me and I can give you some more information. And I think that's a great way to get connected with other human rights legal practitioners and not only about disability rights issues, but about all kinds of discrimination issues affecting all kinds of communities.
Wonderful, thank you. And Roselle?
Yeah, just quickly, I also just want to say that LEAF is not a service provider. So our work is very much sort of internal to identifying cases and developing arguments. But we do have volunteers both doing some legal research and other administrative things that including communications materials. So if folks are interested, please feel free to reach out to me, and I'll also share the volunteer page with information about how to get involved in the chat.
Thank you. And I will turn it back to our learning director, Dr. Linda Baker, to close off our webinar.
Okay, and I'll be really brief because we're out of time, but I do want to express our team's appreciation for the time that all of you took to participate in this webinar, and most of all for the ongoing work that you do. Bonnie with Dawn and Roselle with Leaf and Carrie with ARC. And I say ARC, but I've noticed that others are saying ARCH. So I'll correct myself there, hearing myself. And just to tell you that how much we appreciate, and we'll look for another opportunity to bring you together so that we can continue the conversation. I'd also like to express a special thank you to the Toronto Sign Language Interpreter Services, and in particular, Jillian and Ruth, for the work that you've done today to help this be a more inclusive webinar. Greatly appreciated. And to Angela Jansen, who has done our closed captioning today. To everyone, thank you. And again, just to echo Sarah's repeated messages in the chat, please take time to fill out the evaluation and to get your certificate of participation, knowing that there's all sorts of opportunities to continue your education in this area. And we plan to do that as well. Be safe, everybody, and we'll see you at the next webinar.